Yes, Mr. Chairman. Mr. Chairman, you are live.
Okay, thank you. We'll wait just a couple minutes. Just want to keep us on track. Okay, Carol, go ahead and I'll call the meeting to order.
Representative Bear. Here. Representative Burkhardt.
He's excused.
Vice Chair Duncan. Here. Representative Ayer.
Here.
Representative Gray. Here. Representative Heiner. Here. Representative Sherwood. Here. Representative Western. Here. Chairman Greer.
Here.
8 present, 1 excused.
Thank you, Carol. Appreciate it. With the folks that are online, if I could just get folks to raise their hand on the first topic, which is business ready community amendments, Senate File 113, just so I can get a feel for how many people. Okay. And with that, I'm going to have to go ahead. The governor's office has a plane to catch, literally. So, Mr. Krieger, I'll let you speak first, sir.
Thank you, Mr. Chairman, members of the committee. Rob Krieger, Governor's Office. Would you like me to present the bill or?
Mr. Krieger, why don't you go ahead? I did not see Senator Wasserberg. I mean, it's a simple bill to present,
Yep.
so go ahead.
Okay, thank you. So really on page 2, line 13, we just strike the word infrastructure and insert projects or uses. And I do want to clarify that that's not negating infrastructure projects. Earlier in the bill that allows for those. And then the Senate added some clarification on legality for constitutionality of this bill and these projects. And so on page 3, line 7 through 10, essentially makes these projects go through the Attorney General for that review before it goes to the SLIB board and the Business Council Board of Directors for approval. And Mr. Chairman, to your point, simple bill adds a little bit of flexibility to the Business Council for the BRC program. I think, as we all know, the economy has changed since this program was first introduced about 20 years ago. Some communities still do need some infrastructure and business parks, but some of these communities around Wyoming are a little more further along in their economic development and don't necessarily need that investment. So this change would help really leverage dollars in that program. And the program has been cut pretty substantially over the last 15 years. And so really this change will help make sure we're leveraging the smaller dollars we have. As I mentioned, this doesn't change the application process, the review, those sort of things. It just really will help our communities develop. And I think you'll hear that later this morning, that the BRC program is really vital to our smaller communities. And this slight change will just give them a little more leverage. One example of that is EDA grants. For federal funding, what communities need to do and businesses is usually put up a match to get those funds. This change, we think, could help provide that match, part of that match to the communities to make sure they could leverage dollars better and help develop their economies. So, Mr. Chairman, that's really the bill. And with that, I'll stand for any question.
Committee, any questions? Mr. Krieger, I have a couple. So first of all, with respect to business ready community grants, it's my understanding, and I don't think I've seen any that haven't been, they're always reviewed by the AG's office. Is that right?
Mr. Chairman, that is correct. We have asked, or the business council, I should say, has asked that, even though it's not in statute. And when we were discussing this in the Senate Minerals Committee, they just wanted clarity on that, and we were fine with putting that in statute, that they would make that review process go through the Attorney General's office.
So with, you made comments regarding that the business parks and some of the infrastructure projects have been built out around the state. There's not as much, just say, pent up need as before. I mean, are we better off to just look at the program in total rather than to just ad hoc add in flexibility to this? What is, I mean, you're speaking on behalf of the governor's office. What is the vision or the plan behind this?
Mr. Chairman, thank you. That's a good question. And I think really this bill and this program, this little flexibility would just allow us to diversify a little more in some of our bigger communities. When we've recruited companies, and I know Mr. Durrell from the Business Council is here and can speak on this too. There's some needs that this program won't cover that we could potentially cover with this change to help stay competitive. I know this committee reads as much as I do, sometimes that we lose out to folks like Texas when they're recruiting companies. I think what this change would do would just allow us to be a little more competitive on that front.
So Mr. Krieger, earlier you had said that, the BRC, which I think it has been very valuable to small communities. So this change is going to shift the focus to larger communities. Is that what you just said?
Mr. Chairman, not necessarily, no. We would just add this to allow flexibility for those communities that don't necessarily need infrastructure. The infrastructure piece and the other components stay, because other communities, smaller communities around Wyoming still definitely do need that investment.
So can you, Mr. Krieger, can you give me an example of some of the needs that the governor's office is seeing where this would be useful with this change?
Yeah, Mr. Chairman, thank you. Again, I kind of point back to these EDA grants. Again, with the tight strings we have on our financials right now, I think this would allow us to help these communities apply for those grants, those businesses expand through that. Some of the other ones Casper, I know, is doing sort of a startup fund, and this could help them not put those funds in a startup or in those sort of things, but would help them learn how to do that, create their own capital, those sort of things, and provide their own programs within their communities, not necessarily through the state's programs, if that helps.
So coming from a small school, I guess, maybe I'll just have you explain what you said, an EDA grant. Could you go ahead and explain what that is?
Yeah, Mr. Chairman, thank you. Economic Development Association is the authority at the federal program. They've really opened up, and especially with these COVID relief bills and past few years have opened up grant options for different reasons and different applications that usually require sometimes 25% match, sometimes 10% match. And sometimes those businesses and communities can't make that. So this would help with that, we would hope.
So Mr. Krieger, those are grants for capital. They're not for infrastructure or otherwise a public purpose.
In some, Mr. Chairman, in some instances, yes.
Okay. All right. Committee, any further questions for Mr. Krieger? Okay. Thank you. I understand. I appreciate you finding the time to come visit.
Thank you for letting me go first.
Try Senator Washburger, but Mr. Krieger had to catch a plane, so we were trying to accommodate his schedule. So with that, if you whatever comments you have on the bill, Senator.
Thank you, Mr. Chairman. I'm not real sure what the comments were prior to my arrival, but I am in support of the bill. I think that the amendment that the Senate put on, which requires a review of the Attorney General's office, is an important and good addition to the bill, although the language in the statute says that anyway. It just states it again. Instead of, my suggestion might be to the committee, instead of the word review, each project might be review and approve. But the reason why that was put in, it was put in by an attorney on our side, was because, there's so many projects that Business Council sees, and trying to get an opinion out of the Attorney General's office sometimes is a slow project. And so not having quite a formal written opinion might be best in this situation. But there is an issue with the bill about being compliant with our state constitution. So I'm in favor of the bill. I think it answers all those issues. And I think it's a good step forward. Actually, when we first started Business Ready Communities, those communities were looking at infrastructure. And now we've kind of gotten past that a little bit and looking for other things that they can do. And so I think it's a good change, but I do believe we need to be careful with it. And that would be my comment. And there's other people here who wish to talk about the bill, Mr. Chairman.
Any questions for Senator Wasberger? Representative Duncan?
No questions from the Goshen County crew.
Thank you, Mr. Chairman. So Senator, this doesn't preclude infrastructure, however, correct? So the issue of a gas pipeline in an area that I have, it's going to cost quite a bit. We won't have ownership in it, but we need it. Is that something of a type of project that we'd be able to get to a industrial park that we own, something like that? Would that qualify?
Go
Mr.
ahead,
Chairman,
Senator.
That's a good question. I think that would be a question for the Attorney General to review. On the surface, I'm going to say yes. I know where that pipeline is because it goes through my family's ranch.
Representative Heiner?
Thank you, Mr. Chairman. Maybe the good senator could give us a little definition of this program. Is there adequate funding in there right now for all the projects that are being requested? Are there more projects that are just waiting in line for more funding to come about, or are we pretty much aligned?
Go ahead,
Mr.
Senator.
Chairman, I'm going to throw a lifeline to.
And that might be better for Director Durrell, and we can, if you want to punt to him, that's fine.
Okay.
Yeah. So, Senator Wasberger, you're an esteemed member of the Senate Minerals Committee, correct? But I mean, is it your philosophy that we should just tack onto these programs once we see that they're not quite as useful, or do you think it'd be a good idea for the Minerals Committee to look at this in depth and see the whole program needs to be repurposed this summer?
Well, Mr. Chairman, that's an excellent question. And I would not have a problem doing it either way. I know that the executive branch would like to see this bill. And typically I try and help the executive branch when I can. But I do agree that after 19 years in the legislature, there's one thing that I know for sure. If it's a really good bill and it doesn't make it that first session, you can bring it back. We can work it in the interim, make it right, and so that all concerns are solved. So it would just be those projects that we would be able to do this year that would not be done. And like I said, the infrastructure changes in our community. We've put a lot of money back into our communities, and so we're looking to do other things that are a little bit more innovative.
Yeah. Thank you, Senator.
Thank you.
Appreciate it. 18 years. Mr. Durrell, you want, please?
Thank you, Mr. Chairman and members of the committee. Thank you for your time. I think to add on to some of the things that have already been said, one of the things that I think is really important for everyone to understand is that this does not get rid of what is a really good program already. The Business Ready Communities program is a great program for the state. It has been for a number of years, and this does not really get rid of any of those great parts of the program. What it does is it allows some evolution to the program so that we can take advantage of some more of the funding that's out there, as well as really help a lot of businesses, not just in recruiting, but also in retention and expansion as well. Some of the things that we need to think about with this come around the idea of transition in many of our communities. And one of the things that there are a number of programs out there for transition. However, in most cases, we're not able to utilize these funds to match those because they're not for infrastructure. So I think that's one thing. As businesses expand or as they are recruited, a lot of the things that they really need are services like coaching. They need equipment. They need other things that we cannot currently help them with. And those can be really significant in our communities. And so as we look at this, I guess I look at it as a way to evolve and meet the needs of businesses today and communities, some of the communities today, but at the same time, keep the safeguards and perhaps even make it, add some safeguards to it that we don't have today. And so the process is the same in terms of the application. The process is the same in terms of our team, the Wyoming Business Council team reviewing it, as well as the board of directors that we have, and then SLIB as well. So those things do not change. And we thank you for your consideration of it, and I'm looking forward to questions. Thank you.
Representative Duncan.
Thank you, Mr. Chairman. Director, is there an emergency for this bill in terms of say CARES funds or anything like that, that we have to have this in order to utilize anything? Or is there ability to wait?
Mr. Chairman, Representative Duncan, thank you. Great question. Emergency, there aren't pending CARES Act funds that require this change. But I think in some communities, there are changes that need to be made. And an emergency today, I'm not sure if it's an emergency, but it could be shortly in terms of transitions and our ability to help them. I think it's also really more about an evolution. And so in terms of the timing, I think the timing is right, just based on what we've heard. The timing is also right based on the external factors in the nation. You're seeing a lot of companies want to move. You're seeing a lot of individuals want to move. You're seeing some changes that are going on outside of our borders that we could take advantage of, and this would be a way to help that. So, but in terms of a 911 emergency, probably not.
Representative Heiner.
Thank you, Mr. Chairman. So, Director, are we loosening up the restrictions on this program because you can't find enough infrastructure projects to spend our money on?
Go ahead,
Mr. Chairman, Representative Heiner, great question also. And I think this ties in with your original question about the number of projects that we are looking at. What it does is it helps us make sure that we're utilizing these dollars for the greatest impact of the state. That budget has been cut over the last few years. And so there are a number of projects. We don't fund every project that comes to us. We still analyze it and make sure that it's a good project for the state. But what this does is allows some leveraging of other dollars or leveraging of things that could make a bigger impact in our communities. And so it's not necessarily about, do we not have enough projects out there to fund? It's how do we fund the best projects? Thank you.
Okay. Committee, any further questions? Okay. Representative Bear.
Thank you, Mr. Chairman. Director, could you just give us an example of one of these non-infrastructure projects that were applied for and found that you couldn't do it without this change to the bill or to the statute?
Mr. Chairman, Representative Bear, great question. That's a tough thing to say because we usually stop it at that point because it's not an infrastructure type of a project. So we don't allow that to really go through the process because it's not. And one of the things that we want to make sure is that communities, this takes a lot of time for communities and businesses to put these projects together. And we don't want to waste their time. So that's a tough one to say past projects that might have looked like this. We could talk about future projects that could look like this.
Follow up.
Thank you, Mr. Chairman. Yeah, just looking to find out what kind of demand we have. I know that there's concepts out there, but I'm just wondering if there's pent up demand.
Mr. Chairman and Representative Bear, thank you. Yeah, absolutely. We are seeing some pent up demand in terms of, especially when it comes to the EDA grants that Mr. Krieger mentioned. We're seeing some pent up demand about workforce attraction and people needing a way to really develop programs that bring workforce into their communities. That's one of the biggest challenges to businesses expanding or recruiting businesses here. And we're also seeing those transitions from one, from a traditional economy to another one. We are seeing communities that are facing that today, and this would allow that to happen. So as we look across the state, we're seeing examples of it. We don't have to Katie bar the door by any means, but right now we're seeing examples of that, and that's what we're hearing, which is one of the reasons that this has come about. Thank you.
Yep. All right. I have one question with respect to the council's revised strategic plan. How does this particular proposed amendment fit into that and the long-term vision for the Business Ready Community Grant program in general?
Mr. Chairman, thank you for asking that question. With the state's economic development strategic plan, it really comes down to leveraging those core industries and making sure that we can transition into those new economic sectors. And really, we feel like this could do that because the idea of value added innovation in those core industries, we've talked about that for many, many years, but the Business Ready Communities program doesn't necessarily fit those needs. So when it comes right down to it, it supports the strategic plan very well. And this change opens up opportunities to continue that strategic plan. So thank you.
Okay, then Mr. Durrell, then a more direct question with this is a complete revamp of the BRC would be better than the piecemeal tack-ons here.
Boy, Mr. Chairman, that's also a good question. Again, as I stated earlier, I don't believe that the BRC program is broken. I believe that the BRC program needs to continue to evolve, and this is a step in that direction. It really opens that up. So it's a good program, and we're trying to make it great. So thank you.
No, appreciate the work you do. Josh, you've done a good job.
Thank you.
Appreciate seeing you in person. Thank
Yeah.
you. Anybody in the room wishes to testify on this? Okay, and then while we're doing that, bring Mr. Klessens in, and hopefully we can wrap up, move on to the next subject.
Here he comes, Mr. Chairman.
Okay, go ahead. Please introduce yourself to the committee.
Mr. Chairman, my name is Braden Konar. I'm the Business Development Director for Goshen Economic Development. I am speaking on behalf of the 150 members of the Wyoming Economic Development Association in support of Senate File 113. We support the legislation and policy that provides tools and resources allowing Wyoming communities to drive economic development. When our communities evaluate economic development projects, we target the industries that have the greatest economic impact. These industries provide higher than average wages and expand the economic base of the community and the county. When the Economic Development Association supports tax policy and incentives that allow Wyoming to remain competitive in encouraging ongoing capital investment and primary job creation. This brings flexibility to the program, allowing Wyoming communities to be more competitive while protecting the public interest as amended. Goshen County has benefited from this program numerous times. Most recently, and we have our Evergreen Plaza being constructed right now in the city of Torrington. That project is beneficial because it keeps retirement dollars and state Medicare dollars in the state of Wyoming, allowing those people those retirees and those folks that are interested in living in an assisted living to stay near their families and not cross over the border into Nebraska. For these reasons, the Wyoming Economic Development Association respectively asks for your favorable consideration on Senate File 113, and I'll stand for any questions. Thank you.
Thank you, sir. I'm sorry. What was your last name?
Braden Konar, Connour.
Conn. Okay. All right. Thank you, Mr. Konar. Any questions, committee? Okay. Thank you. Appreciate your comments. Okay, so then we have Mr. Klessens.
Mr. Chairman, members of the committee, can you hear me?
Yes, we can.
Thank you. Good morning, committee, and thank you once again for allowing me to testify in the fashion that we are doing this morning. It's a long ways to Cheyenne from Cody. I wanted to say that my initial introduction to the Wyoming Business Council program was through a gentleman named Tucker Fagan, who was the CEO of the Business Council in 2003. And at that point in time, he described the Business Council as an economic development organization that was nimble and flexible and had the ability to move at the speed of business. And, you know, I wasn't in Wyoming at the time, and I thought, wow, what a great concept that was. In 2008, when I moved to Wyoming and learned the rules of the Wyoming Business Council's program, especially the BRC program, what I realized is that it wasn't as nimble and flexible as perhaps it could be. With the definition of infrastructure as defined in statute. I guess there's an old adage that says that if your only tool is a hammer, then every problem becomes a nail. And I think that's problematic from an economic development perspective, because every business has a different set of needs. Every community has a different set of needs. And some people might need business parks. Other people might need buildings for businesses. Other might need water, sewer, power, that type of thing. But there's a lot of businesses, and particularly this is true in small communities. There's a need for the ability to finance large pieces of equipment or to assist in marketing efforts. The needs of businesses vary. And I think if you limit it to only infrastructure, then that's all you're going to see. And we're going to wonder, you know, how do we help those other businesses? And we're struggling with that on a couple of projects that we're working on at this point in time. You know, I know a lot of people are talking about beef processing in the state and let's build plants and let's do this and that. Well, building a plant is one piece of it. It's like building a swimming pool in a community is a great thing, but how do you pay for it for the long haul? The same thing's true with the meat processing industry. Where are you going to market that product and how do you follow it on? So there's a need for capital beyond just the bricks and mortar infrastructure. And it's really important to think of it that way. I published a report that I did back in October, November of last year, sent it to some people within the state relative to comments that I heard that said every job in Wyoming that we bring to Wyoming costs the state money as opposed to bringing the state money. And I contest that assertion because I don't think it gives the whole story. And so what I did is I took the most common denominator or common definer of economic development, and that's gross domestic product. And I looked at the communities of Park, Washakie, Sheridan, Johnson, Campbell, and Sublette counties. And I took the gross domestic product of those counties and I compared it to the extractive industry taxes. And so if you know how that works, and I know you guys do, that the production of minerals matches the tax. It's a direct correlation. And as you also know, it's been a big U over the last decade. So what I did is I mapped that gross domestic product in those counties compared to the mineral taxes from the state. And what was really interesting is highly mineral dependent communities like, let's say, Sublette and Johnson, their GDP matches that verbatim. But that's not true in Park. It's not true in Sheridan. And it's not true in Campbell County, believe it or not. And I had to look at why is that happening. And so I took and made a correlation between investment by the Wyoming Business Council in infrastructure projects associated with those communities. And it was interesting to see that the communities that invested the most in themselves, just using the tool of Business Council, and we know that other resources are brought to bear, all of those counties have an upward incline in their GDP. So I think there's a correlation to be made there that when we invest in our communities, our gross domestic product increases and therefore our economies are expanding and growing as opposed to boom and bust. And I think that's the measure that I think Senate File 113 provides us is the ability of the Business Council, their board of directors, and under the oversight of the Minerals Committee, obviously the legislature, and with the review of the AG, we have the ability to define programs that truly work in our community. So with that, I would ask you to support this legislation and stand for questions.
Committee, any questions for Mr. Klessens? Okay. All right, thank you. Hope the weather's good in Cody. All right, who else wishes to speak on this? Please raise your hand so I get an idea. Okay, they do have 3 other bills today that are important to the rest of the state of Wyoming. So please come forward with your comments.
Mr. Chairman, thank you. Lisa Johnson, Wyoming Economic Development Association. I was just asked by Mr. Durrell to pass along that another reason this is important is if this change is in place, then we might not be able to take advantage of some of the federal stimulus monies if they do become available.
Yeah, thank you. Who else? Please come forward.
Mr. Chairman, committee members, Kelly Craco, Mayor Town of Alvin, also Wyoming Association of Municipalities Legislative Leadership Chairman. I'm here on behalf of WAM. I'll just keep it short, and I think it's pretty well covered, but just to add on, the easement and restrictions this would do would help bring more businesses into Wyoming. And obviously, the more businesses we have provides job, gets sales tax money to the state, which is not only good for cities, counties, and counties, but it's good for the state as whole. So on and for the bill, and happy to answer any questions if you have any.
Okay. Members, any questions? All right, thank you.
Thank you.
Anybody else? Okay, I'm going to close public testimony. It's the committee's pleasure.
Work the bill.
Moved by Sherwood, seconded by Burkhart. Any discussion on the bill? Just, yeah, just any general discussion and we'll work it, see if we got amendments. No general comments. All right, let's work the bill. Page 1. Page 2. Page 3.
Mr. Chairman,
Yeah, Representative Bear.
I move that we amend line 8 to state review and approve. So insert and approve after review.
I think that'd be correct. Representative Bear, so we would say no grant shall be made under this article without the review and approval
Yes,
of
approve.
the Attorney General. Guys, moved by Bear. Is there a second? Second by Gray. All in favor of the amendment, say aye.
Aye.
Opposed?
No.
Amendments adopted. Any other amendments, committee? Okay. General comments on the bill? Yeah, go ahead, Representative Gray.
Thank you, Mr. Chairman. I'm going to be voting no on this. I think that we're going to have this comprehensive review on this program during the summer. We've got a special session to review the funds on the federal legislation. I think it's important to be consistent. We've heard before that, this review is going to be comprehensive, and yet now we're going to cherry pick one area and say, okay, now we're going to do this now. And so I'm not sure I'm going to be thrilled with the direction of the committee, the final direction, but I'm happy to try to make it as good as possible. But I think that it needs to be part of the comprehensive review that we've heard about over the summer. I'm going to be voting no. Thank you. And I appreciate the comments from the sponsor too, that I understand his passion on this, but I appreciate him acknowledging that could be part of this discussion too. So, thank you.
Yep. Any further comments, committee? Representative Duncan?
Thank you, Mr. Chairman. I was an aye vote on this until the amendment. The problem is that you heard the testimony about things having to go through the Attorney General having to go through an entire an opinion. So what is the difference between approval and an opinion? It's going to tie all this up. And so now that's no different. And so I feel like this is no good. So I'm going to have to be a no, because this basically, I think, killed the bill.
Any further discussion, committee? Seeing none? Go ahead, Representative Sherwin.
Thank you, Mr. Chair. I hope this will help people visualize the process a business or a project has to go through. So you have a local economic development group that may be approached by a business, and the business says, here's our need. Here's what's preventing our growth or expansion or us coming to your community. So there's conversations on the ground that create the template for the project. And then they have to be approved by the city or the county. So there's a process of approval at the local level before the application is even submitted. And sometimes that can take a year. So then once it goes through the local city or the county, then it goes to the business council. And at the regionals, the staff at the business council are working with the business and that entity and the local government. That can take another few months. And then after it goes through staff review, it goes to the board of the business council. And if that gets through that part, it goes through SLIB. So there are multiple checkpoints that the project is vetted. And so sometimes it's taking 2 years to even get to SLIB. And I share Representative Duncan's concerns about the holdup and the backlog that we might see in the AG's office. So this amendment is also concerning to me in terms of us being able to act quickly and nimbly as our economy is in transition.
Any further discussion, committee? Representative Western.
Thank you, Mr. Chairman. So I think the central question on that is how long exactly will the Attorney General take? I don't see anybody from the AG's office, but I think if that's concerned, that's one of the questions that we need to have answered is how long will it actually take? Are we talking whatever timeframe that may be? Thank you.
Any further comments from the committee? All right. Question on the bill. Roll call, Carol. Thank you.
Representative Bear,
No.
Representative Burkhart,
Aye.
Vice Chair Duncan. Representative Ayer,
Aye.
Representative Gray. No. Representative Heiner. Representative Sherwood,
Aye.
Representative Western. Chairman Greer.
No.
4 ayes. 5 noes. That would be a do pass motion that fails.
Okay. Next item for our consideration, Senate File 38. I think Senator Rothfuss, does Mr. Kaufman want to come forward? We might let you guys kind of tag team that. For the love that's all that's holy, let's not talk about this for 6 hours. Can we?
Thank you, Mr. Chairman. We'll try and limit it to 3.
Go
Mr.
ahead,
Chairman,
Senator.
thank you, Mr. Chairman. Committee, we bring Senate File 38, Decentralized Autonomous Organizations from the Blockchain Select Committee. This was probably the flagship work of the off-season. Representative Greer, Chairman Greer, you were involved in that. And it's a new concept. It does not exist elsewhere in the country as far as having a statutory framework for this type of corporation. But there is a tremendous amount of interest and demand for a corporate structure and legal recognition of this type of corporate structure.
So Senator Rothfuss, I'm
Yes.
sorry, but you're right. I was involved in this, much like I'm involved in taking the trash out at my house. So, get it done.
It was about 80% you got
Okay,
it. Yeah.
all right. Clear.
And Mr. Chairman, I'll have Mr. Kaufman walk through it. We worked this through a working group, which included experts really from all over the country that have been looking in this space. And the idea of a decentralized autonomous organization, just at a conceptual level, is a corporation that runs either partially or primarily through automated smart contracts through code. It's effectively executed through code instead of by our traditional manager-based or member-based management where the humans get together and chat over it. This is a new frontier in business, and there are already businesses being set up to do this. Typically what they do is they take a limited liability corporation somewhere, and then they jam a bunch of articles into it to make it so that it behaves autonomously, and then they hope that that works. And seems like it kind of works. We were trying to take it to another level where we actually provide a framework statutorily. We start with our Limited Liability Act. We have a supplement that was prepared that provides clarifications for how one of these decentralized autonomous organizations, or DAO, we call it a DAO, how one would work, so that rather than having to honestly hire expensive attorneys like the excellent one to my right, you might be able to do it a little bit more out of the box and register a decentralized autonomous organization, LLC, in the state of Wyoming, rather than having to build one from scratch each time. Again, this was probably the subject of the most interest we had and have had over this last year. There's a tremendous amount of enthusiasm, but with that, I'm going to ask Mr. Kaufman to walk you through and stop my diatribe.
Any questions for Sandro? Okay, go ahead, Mr. Kaufman, introduce yourself.
Thank you, Mr. Chairman. My name is Matt Kaufman. I'm a partner with the firm of Hathaway and Coons here in Cheyenne, and also a governor appointee to the block chair of the select committee. Mr. Chairman, just following up on those remarks before I dive in, just to give a little bit of context for those of you that aren't maybe super familiar with our LLC Act, recall that our LLC Act has predominantly two types of LLCs: member managed LLCs and manager managed LLCs. This is a subtype of an LLC that is not, as Senator Rothfuss just said, is not designed in any way, shape, or form to amend or change our current LLC Act. This is a supplement, an alternative subtype of an LLC that an entity could form as. It's also designed to only be a member managed LLC. And there's specific reasons for that, which we'll go through, but I just want to create that context as we discuss. Mr. Chairman, with that, I'll start on page 1 of the bill, obviously the introductory language. Mr. Chairman, I'll try to be super brief on this. If I go too fast and you want me to dive into some, just let me know.
You're doing good.
1731-101 is just a short title. We're going to call this the Wyoming Decentralized Autonomous Organization Supplement. Again, it's a supplement to the LLC Act. Diving into the definitions in section 102, we first identify blockchain. This is consistent with how you all have previously defined blockchain in our statutes. We set forth a specific designation for the DAO, Decentralized Autonomous Organization. Digital asset, again, a term that already appears in our statute, and for consistency purposes, we adopt the same definition there. Limited liability autonomous organization, or LAO, it's just another term of art which people will be permitted to refer to their DAO as. Starting on page 3 with a majority of the members, this is where we get into the member managed component that becomes important. We're defining what a majority is. It's simply approval of more than 50% of the participating interests. We also define that a person that's dissociated, a dissociated member at law, is someone who essentially withdraws themselves from participation of an LLC. It may not be a full legal withdrawal from the LLC, but it's a dissociation. And so we take effort to define what the rights of that dissociated member are in this supplement, just like we do in the underlying LLC Act. The membership interest, which is a member's interest in the LLC, we again just define that. In this context, it's slightly different because that interest is defined not only through the articles of organization that are filed, but also through any smart contracts or algorithms that might be supplementing the operation of that DAO.
And so, Mr. Kaufman, I think for the committee, isn't that sort of the key component of this supplement to the LLC law, is that ever evolving and changing nature of those ownership interests? Is that a pretty fair statement?
Yeah, Mr. Chairman, if I may, yes, great question. And really the driving force here is what's occurring is a lot of what used to be traditional operating agreements for entities are now being embedded into code, where there's certain aspects of those agreements, or maybe even all aspects of those agreements, are self-executing. And so this is simply putting definitions around that and putting rights to the members around those self-executing contracts.
Mr. Chairman,
Senator Rothfuss.
I'm going to ask Matt to explain to the committee, because I think it's important, why they wouldn't just want a general partnership when they're doing that project, and why they would want something like this, because we talked a lot about it. But
yeah, Mr. Chairman, if I may, just to refresh the committee's memory on this, when 2 or more people at law join together to form a business, that's a general partnership. When you are a general partnership, all the partners of that business have unlimited liability. So in other words, you're on the hook for everything. The reason, of course, people form LLCs or corporations is to shield themselves from that liability, so long as you undertake and follow the guidance of the statute to perform those necessary requirements to get the liability protection. So this, again, is just another tool in the toolbox for Wyoming business entities where people can undertake to be an LLC, but still utilize the smart contract features of an autonomous organization. Moving on, Mr. Chairman. Again, we define open blockchain simply as a blockchain is defined in Wyoming statutes already that's publicly accessible. And its ledger transactions are transparent. On line 18, we define quorum. On line 22, we define smart contract. Again, this is a term that's already been defined in Wyoming statute. Again, the high point of a smart contract is it's simply programming language, which automates some aspect of a transaction. Moving on to 1731-103, this is where we get into the application of the LLC Act. So again, we're specifying here that this is intended to supplement the LLC Act. This in no way, shape, or form affects the underlying LLC Act. Subsection.
Mr. Chairman, I'm sorry to interrupt. Mr. Kaufman's working from the original copy.
Oh, am I referring to the wrong lines? I
Please
apologize.
take mine, because you're gonna miss one point if you don't use the,
Thank you,
if you
Senator.
don't use the engrossed, and they're gonna care.
So, Mr. Chairman, I'll move on to 1731-104. Let's see, is that where I was?
You were on 103.
Yeah, oh, sorry. So 103B. Again, we're not repealing or modifying any statute or rule. We're simply supplementing the principles of the underlying LLC Act. Moving on to 1731-104. This is the definition and how you elect to be a DAO. Subsection A on line 11. The DAO is a limited liability company whose articles must contain that the company is a DAO as described in subsection C, and we'll go through what the requirements of those articles of organization are. We do set forth in subsection B that an LLC that's already formed may convert to a DAO. Of course, it has to amend its articles and meet the requirements of this section. Subsection C denotes that a statement has to appear conspicuously in the articles regarding that it is a DAO. Again, that gets back to that public notice aspect. We want people to be well aware of the type of organization that they're participating in.
So Mr. Kaufman, on that point, so the articles organization are filed and they can be filed, they are filed and can be found on Secretary of State's office. So the question then becomes, how many individuals have become members of this DAO without become members automatically without the opportunity to see that notice? Does that possibility exist?
Mr. Chairman, that would be, I think that would be relatively difficult. Could conceivably a member join a DAO without looking at the articles? They could, in the same way now that I suppose someone could contribute capital and sign an operating agreement, become a member of an LLC without looking at the articles. But that wouldn't necessarily, that initial step of signing up wouldn't necessarily happen in an automated fashion.
So Mr. Kaufman, I'd probably asked my question poorly then. So every member of a DAO will have to take an affirmative step to be a member and be recognized as a member. Is that safeguard in place?
Yes, Mr. Chairman, that is
Okay.
correct. Someone would have to take an affirmative step.
Okay, thank you.
Mr. Chairman, continuing on in subsection C, we have a notice of restrictions on duties and transfers. Again, this section just simply specifies that the rights of members in a DAO may differ from the rights of members in other types of limited liability companies. Specifically, what we're taking caution here to set forth is that, again, the DAO operating agreement or the DAO rules that are embedded in code may modify, just like any operating agreement for an LLC could, may modify those fiduciary obligations, the contractual rights of the members within the LLC. So again, we're putting people on notice that the DAO rules may modify. Subsection D, the registered name for a DAO shall include the abbreviations DAO, LAO, or DAO LLC. So we're setting forth how these entities have to be designated. And then subsection E is, again, a statement in the articles that not only defines the DAO as either a member managed or algorithmically managed, but you also have to set forth, and we'll go through this in a little bit more detail, you have to set forth and identify this specific smart contract or blockchain that this entity might be operating on. Mr. Chairman, I just want to be clear in this particular statement, we're not intending in any way, shape, or form to create, again, another subtype of LLC. These are member managed LLCs. We just want it to be clear in the act when you file your articles that you need to designate, are we intending to be a member managed LLC with some automation, or are we intending to be a member managed LLC with a lot of automation or all automation? So there's varying degrees of that automation within the member management.
Okay, Representative Burkhart has a question.
Thank you, Mr. Chairman. And I know this morning I feel relatively dense with some things. What is if you would please, Mr. Kaufman, what is an algorithmically managed decentralized organization?
Mr. Chairman, if I may, the algorithmically managed organization refers to that smart contract that I was talking about. You can think about a smart contract as almost an if-then statement, that if this happens, then that happens. I'll give you an example, Mr. Chairman, if I may, of some DAOs that are operating now. They're operating within certain blockchains where you can contribute a certain type of digital asset. Ethereum is a commonly known and used digital asset. Every member, instead of contributing cash, could contribute Ethereum. And then the smart contracts of that operating agreement can go out on the blockchain and can execute trades. So for example, that operating agreement might specify, we're going to buy and sell and trade these types of digital assets, or we're going to invest in these types of projects as long as it's on an open blockchain. And the algorithm can then go out and search for those projects, have price parameters, and execute the trade without anyone actually performing that function.
Thank you.
Mr. Chairman, moving on to 1731-105, the formation section. So again, this just specifies that any person may form a DAO, has to have one or more members. We have to deliver the articles of organization to the Secretary of State. Subsection B, each DAO shall have and continuously maintain a registered agent, just like every other LLC.
Mr. Chairman.
Go ahead, Senator.
If I may chime in on that, this is something that we grappled with a little bit on the select committee, whether or not we wanted to require a traditional registered agent, because DAOs traditionally don't necessarily have that connection. And we decided that this was one of the things we were going to require as your sort of trade-off. If you want LLC protection as a DAO in the state of Wyoming, we're still going to make you have a registered agent. We're still going to provide that registered agent with the same rights and responsibilities that they have right now. And we recognize then that that might be something that some DAO interests might not be willing to do. But that was a trade we chose because, again, we're providing liability protection, and we have to make sure that we're adhering to the same types of protections that we have in place statutorily for traditional limited liability corporations. So that was an essential point. Thank you, Mr. Chairman.
And Senator, and I, for one, thought that was a really good choice by the committee.
I think you did, yeah.
Go ahead, Mr. Kaufman.
Mr. Chairman, thank you. Continuing on line 5, subsection C. Again, we're just clarifying that DAOs can only be formed for lawful purposes. We do have a statement in there regardless of whether for profit. The primary motivation for that qualifier is that a lot of DAOs are being formed right now for the purposes of creating software. So community members can come together and participate in these open blockchain projects through some type of an entity. So that was the only clarifier. We do think that is a major driver here. Subsection D, an algorithmically managed DAO may form only if the underlying smart contracts are able to be updated, modified, or otherwise upgraded. The simple intention there, Mr. Chairman, is we don't want people forming a DAO with some antiquated smart contract that can't be added to or modified to accommodate the members' operations. 1731-106, I've already alluded to a lot of these provisions, but the articles of a DAO shall include a statement of the DAO.
I think you just anything that would separate it from her. I mean, it's a supplement filings.
Yeah, and Mr. Chairman, again, we've already spoken about the requirements to identify the smart contract, the blockchain, any rights and duties for individuals in their capacity as members.
You go ahead, Senator.
I wanted to not skip over the B paragraph though, which is on page 8 in the engrossed. Because this is a key nuance you see where it shall include the articles of organization shall include a publicly available identifier of any smart contract directly used to manage, facilitate, or operate the decentralized autonomous organization. This is, again, another key trade-off. If you want limited liability protection in the state of Wyoming, those smart contracts are going to, the key overriding smart contracts are going to be publicly identified and recognizable. So if you want to do super secret things, you're probably not getting our limited liability protection. And that again is another key trade-off that we wanted to make. Thank you.
Yeah, Representative West.
Thank you, Mr. Chairman. Senator Rothfuss, would the publicly available identifier be like a registered agent, or maybe could you just elaborate a little bit on that for me? Thank you, Mr. Chairman.
Mr. Chairman, Representative, that could be a public identifier for a particular protocol, blockchain, particular contract layer that's being utilized. So again, most of these blockchains are publicly accessible, so we just want them to be identified. And Mr. Chairman, to your question just a moment ago, that's simply what page 9, subsection C really sets forth. Anyone that's filed an LLC recently knows you really don't need much information for your LLC filing in your articles. A lot of that specificity can be contained in your operating agreement. We are requiring more in the article filing for these types of entities. Again, the design here is that these entities are supposed to be publicly accessible. We want them to be transparent so people know what's going on, because they're smart contract driven. So we do require a little bit more in the articles than would otherwise be required. Mr. Chairman, I think with that, we can probably move all the way down on page 10 to 1731-107, amendment or restatement. This is a little different than the LLC Act. We require articles of organization to be amended when there's a change in the name. Continue on page 11, if there's a false or erroneous statement in the articles, or if the DAO's organization's smart contracts have been updated or changed. Again, we just want the public filings to be consistent and for full transparency on these entities. Line 8, 1731-108, the operating agreement. This just simply says, to the extent the articles or smart contract don't otherwise provide, the operation of a DAO may be supplemented by an operating agreement. That might be a physical operating agreement. It might be an operating agreement that exists in code, but nonetheless, an operating agreement is permitted. 1731-109, the management of a DAO shall be vested in its members, or obviously if it's algorithmically managed to some extent, that has to be set forth as well. Again, this is clarification back to that member managed LLC orientation. Down the bottom of page 11, 1731-110, the standards of conduct for members. Unless otherwise provided for in the articles, no member of a DAO shall have any fiduciary duty to the organization. Mr. Chairman, I would suggest this really isn't any different from our underlying fundamental LLC Act. Members don't necessarily have fiduciary duties just by virtue of being a member. So we're just restating for clarity. 1731-111, membership interests for member managed DAOs. Again, unless otherwise provided in the articles or the smart contract or operating agreement, the membership interest shall be calculated on a pro rata basis, just like you would any entity. Everybody contributes some assets, we're taking the total divided by what you put in, and that's your pro rata share. Now that could be modified by agreement of the members, but that's the default rule. Moving on to subsection 2, if members don't contribute digital assets as a prerequisite to becoming a member, then we're falling back on a default where each membership interest has 1 vote. So again, we're just setting it baseline default rule in case it's not clear.
This kind of just break this up a little bit, just the concept of, 5 to 10,000 people working on a piece of code and contributing over little bits here and there over a couple of years, and then the code becomes worth $1 billion in the litigation to be able to prove the interest is, I bet would be some of the most boring time ever spent on the face of the earth.
I'm not sure how to respond, Mr. Chairman.
Would you agree?
Probably true.
Maybe that speaks to what a no.
All right, go ahead,
Mr.
finish your
Chairman,
thought.
yeah. Moving on to 1731-112, the rights of the members, managers, and dissociated members. Again, we're specifying that members shall have no right to separately inspect or copy records of a DAO and shall have no obligation to furnish information to the DAO. So again, the design here is that these are public, transparent entities. So it's designed that the operating agreement, the smart contracts, everything is publicly identifiable and available. So we're trying to slightly shift the paradigm there for how these organizations maintain records.
Mr. Chairman, if I may weigh in and add on to
Go ahead,
that,
Senator.
and you'll see the final clause in that paragraph is to the extent the information is available on an open blockchain, which gets back to that open blockchain definition, what we discussed earlier, where as long as you're being transparent, then you're not independently responsible for providing that information, which is again, something that is helpful for the DAO structure.
Mr. Chairman, moving on to the bottom of page 13, the withdrawal of members. This section specifies that a member may only withdraw from a DAO in accordance with the terms of the articles, the smart contracts, or if applicable, and there's an operating agreement. We do, again, we set forth that a majority of the members can approve the withdrawal of a member. We're trying to, in this provision, Mr. Chairman, protect against some chaos, understanding that these will be member managed organizations with most members participating remotely. So again, we're trying to set some baseline rules. Subsection B, a member of a DAO may not have the organization dissolved for failure to return members' contribution to capital. That would require an action, just like it's required now for an LLC. Subsection C, unless the organization's articles or smart contracts or operating agreement provide otherwise, a withdrawn member forfeits their membership interests in the DAO, including governance or economic rights. So again, we're specifying if you abandon this entity and leave, you potentially forfeit your rights. 1731-114 dissolution. This is a little bit different, Mr. Chairman, from the underlying LLC Act, and that specifies that a DAO shall be dissolved upon the occurrence of one of these conditions. If there's a fixed period and the duration expires, the DAO will be dissolved. If there's a vote by a majority of the members, it will be dissolved. At the time or upon the occurrence of any event specified in an underlying smart contract or in the articles, it can be dissolved. If the DAO has failed to approve proposals or take any actions for a period of 1 year, it can be dissolved or shall be dissolved. Again, since these are to some extent autonomously run, if they start to sit dormant, we don't want to provide them limited liability. We want them to be forced to be dissolved.
So, Mr. Kaufman, I guess I didn't get a chance when we were looking at these earlier this year. With respect to that, by a vote of majority members, that's in statute. And so what we normally see, unless otherwise provided by the operating agreement, can you help me with why that hard line on a majority vote by the members?
Yeah, Mr. Chairman, and we do in the definitions, we define the majority as a majority of those participating interests that are eligible to vote. And the only reason I think we take a little bit more care here as opposed to the underlying LLC Act is, again, assuming that these are always going to be member managed, and that if the members don't participate and exercise their participation, they could forfeit those voting rights.
Okay.
So we're incentivizing people to stay involved.
Okay, all right, thank you.
And then lastly, Mr. Chairman, subsection 5 there, by these entities can also be dissolved by order of the Secretary of State if the DAO is deemed to no longer perform a lawful purpose. So if someone reports to Secretary of State that one of these things is not acting legally, then the Secretary of State has the authority to unilaterally dissolve them. Subsection B, as soon as possible following the occurrence of any of those events, the DAO shall execute a statement of intent to dissolve and anything else required by the Secretary of State. And then lastly, on page 16, Mr. Chairman, the miscellaneous section, this simply states that the articles, the operating agreement of the DAO are effective as statements of authority. Where the underlying articles, operating agreement are in conflict, the articles shall preempt any conflicting provisions. So again, we're trying to create sort of a hierarchy, and we want the articles in this case, not that they aren't with regular LLCs, but we want the articles here to have a little bit higher requirements on what's going to be contained, and those will be sort of final statements of authority for the entity.
Okay.
With that, Mr. Chairman, I'd be happy to answer any questions.
Actually, given the depth of this, good job. So, yeah, we'll go Representative Gray, Western, Air, just go around the horn. Go ahead.
Thanks, Mr. Chairman, and thank you. I know we're pressed for time, but I do appreciate the discussion and going through this line by line, and appreciate your enthusiasm too. I know both of you are very enthusiastic on this issue. I do have the question of, aside from the servicing of these attorneys, how is this going to help grow our economy? And that's my question. Thanks.
Go ahead, Senator.
I'll start with that. This really is the the framework or template that large software development projects are looking to right now as the type of corporate structure that they want. And other large developments, the movies are looking at this, records and albums, a lot of different distributed activity endeavors that are creative and forward-looking are trying to adopt this model. If those are domiciled in Wyoming, I would expect good things. We would prefer them to be domiciled here than elsewhere, and if we can provide that structure. Is it a complete solution? We probably have to do more, obviously, and we need to entice them to spend time here and be here and have some bricks and mortar here as well. This bill does not do that, but again, it's consistent with what we did with the LLC Act originally. We put together a first of its kind, best in show approach to a corporate structure, and it was nationally recognized and adopted, and I think that was a big thing for Wyoming. And that is the intent here, and it integrates very well with the other work that we've been doing, and you've seen the digital identity legislation and some of the other things that are going through, and these are all pieces of those and the blockchain work. So again, it's a piece of a puzzle. It's a piece of a puzzle that's heavily in demand, and I'd encourage everybody to just start, scrolling around and looking around on the internet and Google and looking up DAOs and seeing the interest and enthusiasm. And if we can be the focal point for this new emerging marketplace and technology, I think that's always going to be good for business development in Wyoming, even if I can't guarantee, all right, well, here is exactly the path to profit.
Mr. Chairman, if I may just add to that really quickly, I would say, Representative, as well, that there is an enormous theme right now happening within finance, within technology companies, and that is the theme of decentralization. We saw it with this last election cycle and people being angry with social media companies' ability to censor people. There's a movement out there to start moving capital and funding enterprises that support decentralized control as opposed to centralized control. This would be truly the first entity type in the country that would enable something like that. And so there's a tremendous amount of excitement about this. And so in terms of what does this do for our local economic development, I think it does a lot, actually, because it enables some new entity types and some new capital investment mechanisms that don't currently exist anywhere else.
Yeah, go ahead.
Mr. Chairman, so this is viewed as a way to push back on cancel culture a little bit. I mean, is that part of what you're saying?
Well, Mr. Chairman, if I can, I don't know that that's the specific driver here. I can't say that. Could it be used in that way? Sure, I suppose it could. I'm just suggesting that a common theme right now in software development, in technology, in capital is just that. It's decentralization. It's creating entities that are controlled more broadly by groups of people that have an interest, as opposed to single centralized control. And that's what this enables.
Representative Western.
Thank you, Mr. Chairman. Mr. Kaufman, just kind of getting back to the question I asked earlier on page 9, line 1, the publicly available identifier. Would it be worthwhile to put that in definitions, or do you think that might be excessive or superfluous?
Mr. Chairman, I'm just finding that. Oh,
on the engrossed copy.
Yeah, Mr. Chairman, Representative, we could. We say in multiple places and a requirement of the articles that the smart contracts obviously have to be identifiable, upgradable, modifiable. There may be a public identifier for these. There may not always be a public identifier because there can be private blockchains. And so I think that's probably where we ran into some snags with forcing that into the definitions. If that answers your question, Mr. Chairman.
Okay. Representative Air.
Thank you, Mr. Chairman. Before I ask a question, I got to admit I'm underwater here by a long ways. But I want to go back to on page 13 under 1731-112, where it talks about the organization shall have no obligation to furnish any information concerning the organization's activities, financial condition, or other circumstances. That just seems to be an open invitation for people to be cloaked in secrecy and engaged in nefarious activities without being able to disclose what they're doing. And I guess maybe I just need better explanation of what it means to the extent the information is available on an open blockchain.
Mr. Chairman?
Yeah, go ahead, Senator.
Thank you. The key is the members part, right? And to the extent that it's available. So the idea that you're going to have 1,000 individual members and none of them are really going to be the managers, right? Because this is not manager managed. This is the member managed and autonomously managed. One of the attractive points of the DAO is that the people don't want to have to be taking the phone calls, so to speak, and answering the business paperwork and responding. They want to be working towards the product. The idea here is those individual members will not be responsible for providing those records, et cetera, as you might traditionally. But again, the key language is on the last clause, to the extent the information is available on an open blockchain. In other words, my articles, which are openly available, are going to point to a blockchain which says, here's the information that you need. If the information that you need is available then at that address, which is going to again be on an open blockchain, that means it's transparent, it's open, it's readable, then that's sufficient. And that's one of the keys to what DAOs are interested in, is that independent sufficiency, where the code is sufficient, assuming that the code is available for you to read. And again, there's some sophistication that has to take place there, but the same is true of an LLC. You have to have some sophistication if you want to be looking and understanding the articles of incorporation of an LLC. I can read them, but I don't necessarily know what it means unless I have an attorney that is familiar with the law and can provide that. So that's the analog we're trying to set up. And again, we're trying to provide for the advantages that are sought with a DAO, but then hinge the limited liability protection on transparency, which doesn't have to be there for a traditional DAO. If you don't want a DAO LLC in Wyoming, if you just want to do a DAO, you don't have to be transparent. You can be encrypted, it can be on a private blockchain, it can be hidden. But if you want LLC protection, that information is going to be transparent, and you're going to have a registered agent to tie back to. And those strings are what we're making the trade based on to get that LLC protection. And that's effectively what the individuals want, Representative. And I hope that provides some comfort.
Go ahead, follow.
Just to make sure I understand what you said. So if it's available on an open blockchain, then if I'm sophisticated enough, I can go there and get all of this information. And I'm supposing if I'm playing in this arena, I would be that sophisticated.
Yes, correct.
Representative Bear.
Thank you, Mr. Chairman. That created a little bit of confusion for me because I'm looking at on page 8, paragraph D here, where we talked about the algorithmically managed decentralized autonomous organization. And we talked about the underlying smart contracts have to be able to be updated, modified, and otherwise upgradable. And maybe I'm wrong about this, but my understanding is once something's in a blockchain, it is uneditable. So is the underlying smart contracts on the blockchain, and would it be part of the information that Representative Ayer was asking about?
Yeah, I'll start, and you can. When you edit on blockchain, you don't delete, you do something new. The history on a public blockchain is going to be there. So you'd actually be able to see every amendment that was made through history. You know, you can, it's almost like you can strike through, but you can't make it go away. So that's probably the simple answer. But again, there is the possibility of having pointers off the blockchain to member agreements or something along those lines, which might be editable. And again, that would be similar to LLC type member agreements that would not be part of their or articles. So there is that analog possibility, and smart contracts can be looking outside of the blockchain for their information as well. So things can change. But again, what's in the articles, which is the underlying smart contract foundation, needs to be open and transparent. And if that's insufficient, if it looks unlawful, remember that we've got, and that's one of the reasons why we've got the unlawful kickout for the Secretary of State. It starts looking sketchy. The Secretary of State is empowered to say, we're not providing limited liability protection anymore because this just looks dodgy now. It does not look lawful.
Okay, any further questions? I mean, we'll hold these two here. What I need to do a little bit of time management. Who, I know Mr.
Chairman.
White's going to want to testify.
Yeah, Mr. Chairman, I have one more thing to say, and my apologies for backtracking a little bit because we did make one change to what you know about how this works, and we ended up just kind of glossing over it. And I wanted you to be aware of it because it's new language from what you're used to. And it's in the definition of membership interest, which is somewhere around page 3.
Yeah, I've got it.
Okay. You see new language. A membership interest may also be characterized as either a digital security or a digital consumer asset as defined in statute. These are previous statutes. If designated as such in the organization's articles of organization or operating agreements. So by default, the LLC is pursuant to UCC code, traditional, what, intangible property?
General intangibles.
General intangibles. Wyoming's the only state with a definition of digital asset where we clarify through our UCC statutes, through the digital asset work that we did over the years, how a digital asset is treated differently. And because we have that in place, we are allowing a DAO to opt for either standing. The default is traditional LLC, but if in your articles you choose to, you can opt to be treated as a digital asset under Wyoming statute. And we had a UCC expert to actually come to us and suggest that we add this language. This was somebody that was familiar with our statutes, how a DAO works, and UCC code, and said you really should provide for that option because you'll be more attractive. Nobody else in the country can do that. And we thought providing that opportunity to have either standing would in fact make us very attractive and take advantage of our previous statutes. And that was not something we discussed before. So I wanted to make sure that was on your radar, Mr. Chairman.
I appreciate that. I'd have to see why that would be more attractive, but I don't think it's anything to worry about. Okay, let's do this. We've got to try to move on. And I realize these blockchain discussions can go on, until forever. Who in the audience wishes to testify on the DAOs? Okay, I'm not seeing any hands. I do want to hear from Mr. Wright. Is there anybody else online that wishes to testify on DAOs? So lift your hand or raise your hand. Okay, Carla, let's get Mr. Wright brought in. I just so people can manage their time. We're not going to get to the fourth bill, which we had listed, which is local impact assistance payments. That'll be moved till Friday. Carol, would you call Representative Larson Lloyd or send him a message if you're able to? He should be up in JC. Tell him we will not be hearing his bill. Okay, then we'll get to you, Mr. President, soon. Well, whatever you are. It's your highest office attained, being respectful. Go with it. All right, Mr. Wright, welcome.
Thank you so much, Chairman Greer, and thank you to the other representatives on the committee. My name's Aaron Wright. I'm a professor at Cardozo Law School in New York. My research focuses exclusively on blockchain technology and these underlying smart contract systems. I think the previous testimony really walked through the bill in great detail. I do think, in my opinion, that the bill does strike this appropriate balance between enabling these new organizational structures, while at the same time making sure that there's appropriate controls that are put in place. I just wanted to note, just for some additional color, the growth of DAOs. About a year ago, there was about $10 million worth of digital assets that were being managed via these structures in a very inchoate form, like was described in the previous testimony. At this point, it's nearing well over $1 billion in these assets. So there's tremendous growth and tremendous opportunity for these structures. And I do think that this will create opportunities for Wyoming and also create opportunities for responsible software developers or other folks that want to explore this structure. So I just wanted to note that and say thanks for the opportunity to testify.
Members, any questions for Mr. Wright? I can assure you, if you ask him a question, he will be able to answer it. He's worked with these folks with the blockchain committee all summer long, brought some valuable insight, also some real reason in how we got the balance on this to make this work in Wyoming. So appreciate you taking the time testifying with us. Okay, thank you very much.
Thank you.
Anybody else wishes to testify on this? Okay, with that, I'm going to close public testimony. Okay, was a moved by Duncan, seconded by Western. Okay, committee, I'll tell you, it was engaged. So I've been an advocate of our blockchain work and moving forward, but I've tried to be the skeptical advocate of this. Senator Rothfuss and I spent many long hours arguing with one another, which I think resulted in Mr. Kaufman coming in and Mr. Wright as well, is finding the right compromise of how we move forward with this vehicle, but also put some protections in place that were mentioned. To me, one of the biggest moves is when we made this a supplement that we did not in any way, shape, or form attack or damage our LLC laws. This is a supplement that lays on top of that. And then also the registered agent and the tieback, and there were several other real protections that are in there. So as being a skeptic, I was convinced that this is well worth the look at for Wyoming. So those are my 2 cents on it, having been involved all summer long with this. Okay. Committee, you want to work the bill page by page? Any comments, any amendments anybody has? Okay, question on the bill being called.
Representative Bear.
Aye.
Representative Burkhart has submitted an absentee ballot of aye. Vice Chair Duncan. Representative Ayer.
Aye.
Representative Gray. Representative Heiner. Representative Sherwood.
Aye.
Representative Western. Chairman Greer.
Aye.
The 9 ayes do pass.
Senator Rothfuss, is that being carried by who?
I believe
That'll be a good way to burn about 4 hours of floor time with that group. Well, good morning, Chairman Perkins.
Good morning, Chairman Greer, Mr. Speaker Pro Tem.
I had 4 hours of sleep last night. I'm not in a good mood, so make me happy, Chairman.
I don't know that he's been in a good mood since March the 1st.
All right, next bill for our consideration, Senate File 136, brought to us by the good Senator Perkins.
Thank you, Mr. Chairman. It's nice to be in front of the best committee of the House of Representatives. And now that my blatant pandering is done, I'll go under the bill.
You know, you're making me feel better all the time. Keep going.
Right, thank you. Mr. Chairman, this is a bill that actually we started some management audit discussions in our management audit committee this summer. And we talked about the PSC, and one of the things that we came up was talking about the lack of the authority to consider externalities, particularly cost externalities related to the utilities' major facility decisions. You know, and that's certainly been highlighted, particularly with respect to reliability as well as other cost externalities. There's 2 things that have happened, I think, that make this bill particularly relevant. One of them is the recent snowstorm and the lack of power and the power outages in Texas. It shows that reliability and availability are 2 very significant issues that need to be examined in our grid and in the provision of make sure we have reliable and affordable as well as available electric power. The other thing that I think it also points out, one thing with respect to cost externalities is, if you remember a year ago, we were all, the last couple of years, we've been talking about a certain IRP, an integrated resource plan by a major utility. And one of the issues in there, there's a cost externality that appears in there that drives a significant conclusion or drives that, and that's the cost of carbon. And that cost of carbon is a cost externality. And so that certainly drove a significant part of the integrated resource plan of that. And one of the things that came up was there was a study done that if you went, what if you took one of these retiring coal-fired power plants, if you captured the CO2 stack and pulled it off and put it into the ground, and either one, there were two scenarios. One was you just simply pulled it off and stored it and offset that with the cost of carbon that people were talking about. Or two, if you pulled that off and used it for enhanced oil recovery, so use it for a CO2 injection, you do those two things. What would that do? If that was an alternative in the integrated resource plan, what would that do to the integrated resource plan? And the conclusion from the study was that in either scenario, even if you just captured it and stored it, it still reduced the cost of the integrated resource plan. It would reduce the cost of the integrated resource plan as presented by that utility. So that went to the PSC, our Public Service Commission, and there was a big fight. They had a big fight about whether or not they could even consider that. There were all kinds of motions to suppress it, to throw it out, to not consider it. Ultimately, the PSC made a ruling that they would consider it, that they could consider it. But that brings us to this bill, which now gives them the discretion, doesn't require it, but gives them the discretion to do a couple things. So, Mr. Chairman, this bill is really a simple bill. The explanation takes a lot less than the previous bill. Mr. Chairman, one observation that I know the good senator here and the good lawyer here, and they're very caught up in blockchain. The one comment I would make is with the open blockchain, it's like having your corporate record book on the open blockchain. That's what they're talking about, their disclosure. You have a corporate record book, you have your minutes, you have your articles, you have all that stuff, and usually that's in a file or maybe digitally on somebody's computer. In this case, it would be open on blockchain. But anyway, that's my one comment, my thought, my takeaway from the previous hour of testimony. But anyway, what this bill does is goes into two places. So this is a 37, it only affects one statute, 37-122, which is matters considered in fixing rates and orders regarding the changing of services or facilities, and which also identifies facility contracts. So you go into subsection A, which is existing law, and the only change is you see at the very bottom on line 15, it strikes out the word or and puts and. And so this says when you're considering rates, they'll consider not availability or reliability, but they'll consider availability and reliability. I think that's highlighted by the events in Texas. You want both, you need both. And considering your rates and how they are, it's important that be done. So that's the first thing it does. The other thing that it does is then obviously in line 10, it adds a new subsection E. The commission may in all matters relating to plans, proposals, or applications. So that's applications for construction, that's applications to decommission, or other proposals, plans, which would include integrated resource plans that we mentioned just a minute ago. Plans, proposals, or applications for authority to construct or retire major facilities having any immediate or potential effect on rates charged, because that's what the PSC does mostly. It talks about rates, what it is, rates, and what's built into the rate in consideration of reliability, availability, and the other things that the PSC considers. So effect on rates charged to customers or to recover through rates any cost thereof, consider reliability and cost externalities incurred by the state of Wyoming, included but not limited to economic, employment, and viewshed impacts. So, Mr. Chairman, as you know, when we talk about cost externalities, then we say including but not limited to. That means that that's a list, but it's not an exhaustive list. It's just a number of some of the things they can't consider, and they consider anything that's similar to that very thing, or quite frankly, anything that's a cost externality. And so, in the testimony we had on the bill in our committee in the Senate, the consumer advocate underscored the fact that Wyoming doesn't consider cost externalities. Almost every other state in our region does consider cost externalities. So, Mr. Chairman, that's the couple of the comments. That's the explanation of the bill. A couple of the comments I would make that generally, like I said, it came out of some management audit discussions as we kind of, management audit committee may very well be the home to the Office of Consumer Advocate. So we started learning about PSC. in this past interim. It requires the PSC to consider reliability and availability in service of service and rate cases, where before there was one or the other. It creates a new subsection that we just went through it gives them discretion, not requirement, but discretion to consider cost externalities. It provides some policy direction to what the PSC may consider, which was the issue in the recent IRP investigation. That was that big where they had this other study came in and whether it could be considered or not. It would provide policy direction to the PSC to do that. It does not require them to consider a specific list of cost externalities, but leaves it open because it is an evolving Senate issue. And then the difference between what this was the Senate amended it to address technical comments provided by the PSC about the proper location and how that would work and how it would fit into their abilities. And the testimony that they provided to us was that they're already willing and able to do this, and indeed have done it to some degree in the past. But this makes it clear that they can in the future. So, Mr. Chairman, that's the explanation of the bill, and I stand for any questions.
Okay, well, thank you. Committees, we'll start here. Representative Hunter.
Thank you, Mr. Chairman. Thank you, Chairman Perkins, for being here. I'm a strong supporter of this bill. At the very end, you talk about viewshed impacts. Could you provide a little more granularity, what your vision is there of what this viewshed impacts is?
Your vision on.
And that was intended.
That's a good point. I like it.
Mr. Chairman, first of all, let me thank the good representative, because I hadn't heard the term granularity in this session yet. So thank you for bringing that back. Just the fact that we can talk about granularity in a context other than IT makes me really happy. So quite frankly, I think when you think about cost externalities, they always have the ability to cut, Mr. Chairman, both ways. They potentially could increase rates, but they also may potentially decrease rates. And so you have lots of other ways that you consider viewshed. We have the Industrial Siting Commission. You have the Antiquities Act. You have all kinds of things. As these things go out, this doesn't say whether you can locate it in a certain area or not locate it in a certain area. But are there cost externalities? Are there costs to the local communities? Are there costs to the state? Is there cost to tourism? Are there costs to other businesses for the loss of that viewshed? A ridiculous but stark example would be, what if someone wanted to stick a big coal-fired power plant in front of the Tetons? Or what if they wanted to stick a big, they wanted to have a 2 square mile solar array in front of the Grand Tetons, or out on Antelope Flats, or maybe they would like to stick a windmills on top, somewhere along the top of the Teton Range because they get good wind up there. That's a cost externality. It would have a devastating effect on Jackson Hole. Why wouldn't we want to consider those types of costs and the effect it would have on the local economy, besides just, and despite the fact that it might provide a cheaper or more affordable electrical rate? So that's the idea behind doing that, Mr. Chairman.
Thank you, Mr. Chairman. Chairman Perkins, one of the things that the power plants are struggling with is the haze mandate that we have to reduce haze. And I see that as part of this viewshed. If we capture the carbon, that captures haze as well. So, this kind of verbiage could also be employed to strongly encourage our coal-fired power plants to embrace carbon capture, because it does help our viewshed as well. Would you agree with that?
Mr. Chairman, I would. I mean, when we talk about cost externalities, they can cut both ways. And this provides, obviously with the regional haze, with what the EPA has done with regional haze and other things, there's a cost associated with compliance with regional haze and how you do that. And so, when you come into either authorizing construction or decommissioning of facilities, or in rate making, it allows the PSC to take those costs into consideration, so that they're reflected in either the rates or in things that affect rates.
All right. So, committee and members, I want to try to get through public testimony here in about 20 minutes, so we can work this bill. Bill came out of the Senate with strong support. So what I'm interested in are any concerns or issues on this that need to be addressed to this committee. So with that, if you're online, please raise your hand. Okay, so we do have hands up from the PSC. So let's bring the PSC in. While they're coming in, who in the audience wishes to testify, just so I can get a hand count? Okay, so we'll go ahead. We'll start right here in front. I had you wait till last time. So come on up while we're bringing in the PSC. Folks, we do need to move through this. I'm going to cut testimony off at 10:50. So, or 9:50, excuse me. Go ahead, ma'am.
Thank you, Mr. Chairman. Thank you, Mr. Chairman and committee. My name is Denise Parrish. I'm a retired utility regulator, 41 years as an analyst. I just, when I look at this bill and think of the analytics that I would have tried to go through if this bill had been implemented when I was working up until a year ago, I would have a very difficult time trying to understand how to quantify some of these things. They are so out of the bailiwick of the PSC and what they have worked on for decades that it's very difficult. And to try to think this through, I tried to come up with an example of, for instance, the economic and employment and viewshed impacts. Just to sort of give you a very quick example is that when I was in high school, my father lost his job, which was devastating to the family in the short term, but it was great for me because I was applying for college scholarships and I got a lot of grants based on the family economics at that time. And so when I'm thinking about the impact to communities, am I thinking about the long run of I got a college education out of that? Am I thinking of the short run that my family had unemployment at some point? How do I take all of those things into account when looking at this? This is just such a unique and very open-ended, very broad set of criteria to consider that has never been considered in PSC cases before. I worry that this will just be overwhelming in PSC cases, which are already very complicated. And I worry that in the end, it will be so open-ended, it will be difficult to consider, to quantify, and to in the end, potentially raise rates to ratepayers.
Thank you. Any questions, committee? Okay, we appreciate it. We're going to keep moving through so everybody get their comments in. So do we have, was it Commissioner Throne had come in to the room? And then why don't we go ahead and bring in Shannon Anderson? So we've got her.
Yes, Mr. Chairman. Ms. Throne is in the room and Ms. Anderson is coming in.
Okay, yeah, Commissioner Throne?
Mr. Chairman, can you hear? Oh, sorry.
Yes, we can
Here's
hear
my
you.
Video. Good morning, committee. I don't have a lot to add, Mr. Chairman, to Senator Perkins' explanation. I think he brought it all in front of you. I would just add that during the recent IRP investigation, we had a lot of community participation and we didn't have any tools to address their concerns. And so I think that was part of the genesis of this bill, to have us start developing such tools.
Okay.
And I can answer any questions.
Any questions for Commissioner Throne? Okay, I think you just got off easy. So
Thank you. I appreciate that.
You bet. All right, Mr. McGagnon, did you have your hand? Who had their hands up again? Chris did. And okay, yeah. So Jim, why don't you come up and then Shannon, we'll get to you next. Carla, while we're doing that, go ahead and bring the next person up, which is, I believe, Abby. It's right on the edge of my vision up there. Okay.
Yes, Mr. Chairman, here she comes.
Okay,
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockbrokers Association. Just one specific point in here that is of concern to us that I'd like to address, and that is the viewshed impacts. The bill talks about cost externalities. The others can be measured to some degree: economic, employment, items, specific items such as the one mentioned by Representative Heiner of air quality can be measured. But the term viewsheds has taken a very broad meaning in recent years to say what I'd like to see that as a neighbor or don't want to see. And it's really starting to have a significant impact on private property rights. It's dealt with by the counties in county zoning, county planning. It's dealt with by the EQC in certain aspects. And we would don't otherwise have a position on the bill, but would ask that if the committee moves the bill forward, that term would be removed or some other more. And I think even as it stands, it does not preclude them from considering something like haze factors and that. But the term viewshed is just an invitation to have everyone stand up and say, this is the view that I like, and here's the view that you like, and the two are in conflict. With that, Mr. Chairman, I'd be happy to take any questions.
So, Mr. McGagnon, that means that old tractor that you hold so dear sitting out front might be impeding somebody else's view shed?
That is very true, yes. And we're seeing it to the extent that, you know, my cows might be impeding someone else's view shed of what they would like the view shed to look like.
I understand. Okay, thank you. All right, we'll go with Shannon Anderson next.
Okay, thank you, Mr. Chairman. Appreciate the opportunity to testify this morning. I'm Shannon Anderson on behalf of Powder River Basin Resource Council, and we're speaking in opposition to the bill this morning. We do agree that economic, employment, and viewshed impacts are important considerations for the state as we close and create electric generation facilities, but they are considerations best left for other agencies, both state and federal, to address. After the public comments received during the Integrated Resource Plan investigation case that was mentioned by President Perkins, stakeholders and the PSC have been discussing ways the agency could potentially consider these impacts, but the conversations have raised significant implementation issues, and the consensus is that the Public Service Commission is not the right agency. As mentioned by Ms. Parrish, the problem you have for the Public Service Commission is what is the value of these impacts? And even if that value can be established, how should the Public Service Commission incorporate those impacts into its decision making? So really the question, Mr. Chairman, is will the bill just create analysis without results? And if there are results, what will they be? Will the Public Service Commission have to compensate employees, landowners, and communities for these impacts? Will utility customers have to pay more in rates to account for these impacts? What will happen? What does the word consider in the statute really mean? The bill's regulatory uncertainty will likely create costly disputes between utilities and other parties, and create other unintended consequences. We just ask you to think about, what does this bill do? And what decision are you asking the Public Service Commission to make? And what consequences does that have? We ask you to vote no on the bill and leave these important discussions to other state agencies that have the expertise and jurisdiction to not only appropriately consider these impacts, but also to address them. Thank you. I appreciate your time this morning, and I'd be happy to answer any questions.
Representative Burkhart.
Thank you, Mr. Chairman. Ms. Anderson, you mentioned other state agencies. Which agencies are you referring to?
Yeah, and Mr. Chairman, Representative Burkhart, it depends on the topic, but specifically for viewshed, there's the Industrial Siting Council, and then there's also county agencies now under the bills that you've been passing. And then the federal agencies are any agency that could potentially consider viewshed in, say, like a National Environmental Policy Act review. So the national park example that President Perkins brought up, that would require review by the National Park Service under the National Environmental Policy Act. And I guarantee that there would be public comment in opposition to that proposal. And that would be a much better place to consider that issue again versus some kind of rate case before the Public Service Commission. On the socioeconomic issues, as this committee is well aware, there's things like the Wyoming Business Council. There's numerous state agencies that deal with employment, job loss, job retraining. There are community colleges that deal with these issues. There's both local, state, and federal economic development agencies. And I think even the utility itself outside the Public Service Commission process is also considering these issues. They have commitments to job retraining and other ways to mitigate employment loss from the retirement of facilities. And they're working with our other agencies, not the Public Service Commission, to make sure those impacts are addressed. So I do believe there's adequate consideration in other state and federal agencies where we don't need to bring this before the Public Service Commission, again, in a way that will create a lot of uncertainty and just implementation issues for the agency and other parties.
Okay, committee. All right, thank you. Well, we have Mr. Brown come forward, and then we'll go with Abby, and then we're like Ken. Is it Ken Hamilton? We'll let him in. Carla.
Yes, sir.
Okay, thank you. Go ahead.
Good morning, Mr. Chairman, members of the committee. Chris Brown, representing Powering Up Wyoming. We are a Wyoming grassroots organization supporting wind, solar, and storage as part of an all of the above energy strategy in Wyoming. And we also have concern, like the previous speakers, about the viewshed component being listed under the PSC's oversight. To cite a project, it already is a rigorous process through the ISC and through local government regulations. And so to add this oversight to the PSC, we feel like will give an additional platform to groups opposing a project to argue viewshed concerns. And so from our perspective, this could raise concern for businesses looking to invest in Wyoming as one more additional hurdle to have to go through in order to make those investments and realize those projects here in the state. And so if the bill does move forward, Mr. Chairman, we would hope that that piece would be removed. Thank you, Mr. Chairman.
Yeah, thank you, Mr. Brown. Committee, any questions? Okay, we're good. Okay, Abby Briggerman, please.
Thank you, Mr. Chairman. I'll keep my comments brief in recognition of your timing constraints.
Thank you.
My name is Abby Briggerman. I am with Holland and Ahart, and I represent the Wyoming industrial energy consumers along with Thor Nelson, whom I know many of you know. WYEC is an unincorporated association of approximately 20 very large companies that all take service from Rocky Mountain Power. Collectively, they encompass approximately 50% of Rocky Mountain Power's load. Electric rates are extremely important to our members. They encompass an enormous portion of their cost of doing business here in Wyoming. And just to give you an example of the cost of their electric bills, one of our members paid over $66 million in electric bills in 2019 alone. So it is a major component of their cost of doing business, and keeping electric rates low and service reliable is extremely important. To that end, they participate regularly in proceedings before the Public Service Commission. Specifically to this bill, we recommend striking from the bill the portion of the text that begins on page 2 at line 15, anything after the phrase, the word reliability. That is anything relating to cost externalities and viewshed impacts. Our concerns are that this really strays from the core mission of the Public Service Commission, which is to keep service reliable and rates low. I have worked with Ms. Parrish a lot in the past, and I would underscore her comments exactly. We share the very same concerns that Ms. Parrish highlighted earlier. The same goes with the comments of Ms. Anderson. There are other organizations that are better suited to review these issues and not the Public Service Commission, specifically the Industrial Siting Council. And really we are very concerned that this is going to open a Pandora's box of issues at the commission. I provided testimony before the Senate committee on this very same bill and discussed that really, to most anybody, their view shed is their Grand Teton. So to the extent that this bill opens up a discussion for any development of any large facility, it is going to be a Pandora's box of issues at the Public Service Commission. And in recognition of the timing constraints, I'll conclude my comments there, but I'm available to answer any questions.
Okay, well, thank you. Committee, any questions? Okay, seeing none. All right, last in person, and then we'll go to Kristen Gunther, and that should wrap up our comments. Go ahead, Mr. Kaysen.
Thank you, Mr. Chairman, members of the committee. My name is Rick Kaysen, and I'm speaking on behalf of Rocky Mountain Power this morning. I am, again, with the time constraint, this is a very important bill. We spent roughly 50 minutes on the prior bill, which is also very important to this state. And I hope the committee will have an opportunity to maybe carry this over to Friday to get more public comment. But very briefly, sir, we are deeply concerned about this
So,
bill.
Mr. Kaysen, what other public comment would be necessary?
What whomever else wishes to speak, either online or behind me. I'm not sure who else wishes to speak. I did not see all the hands raised or whom is online. But again, very briefly, sir, this bill, two components. One, reliability. We agree with that. Reliability is extremely important, and Rocky Mountain Power has demonstrated over the years that its reliability is good. We build our systems from generation to transmission to distribution to withstand the Wyoming environment. And lastly, the second component of this bill that is most disturbing, and that is the cost externalities, and you've heard enough about that. And so I will not repeat those, but bottom line, our interpretation of this bill, again, with other comments, this bill will result in higher rates for the electric customers, not only of Rocky Mountain Power, but of all of Wyoming customers. And there's many of examples with what the impact of cost externalities. But again, sir, with due respect and your request for time, I'll try to answer questions that the members may have.
Well, no, Mr. Kaysen, I don't want Rocky Mountain Power thinking they didn't get full time to speak in front of this committee. So go forward with all your comments.
Okay. And sir, it will go beyond your time though to
Fine.
get back to commission. Okay. And thank you for that latitude. That is greatly appreciated. So three parts. One is the low cost for customers. Again, Rocky Mountain Power rates are some of the lowest across the.
So, Mr. Kaysen, but please don't repeat the testimony you gave us last week. So tell us what's new regarding this bill.
We'll just go right to the specifics of the
Okay.
bill then. All right, sir. Again, I identified the two things that this bill does. One is the reliability, and two is those on page 2, lines 15 through 17 that addresses the cost externalities. And again, you've heard much about what cost externalities mean. And there's no guarantee that any addressing of the cost externalities is going to improve reliability. It really has no relationship with that. And so again, there's an imbalance right there. Again, this is going to affect all of the Wyoming electric customers, and there's going to be a trickle-down effect as well. Not only from, for example, from the industrial customer who produces a product to the consumer who purchases that product, their cost of that product is going to be increased because of higher electric rates.
So, Mr. Kaysen, in that vein, when Rocky Mountain Power is putting together their integrated resource plans, they're dealing with different externalities that aren't directly related to reliability when they're making their economic decisions. Is that not true? I've read this.
Mr. Chairman, I think that's a fair characterization.
Okay, so then why shouldn't the PSC be able to come around, and it says may have those same considerations when they're looking out for the citizens of the state of Wyoming? I'm having trouble reconciling the position of the company you're representing with what we're trying to do for the citizens of the state of Wyoming.
Mr. Chairman, the comments that I'm providing are directly from a utility provider and not the other things. And yes, cost externalities are included in a integrated resource plan about what that impact might be. But this bill also changes the format that has been used successfully for decades and decades by the Public Service Commission, and that's low risk and from reliability standpoint, as well as keeping rates as low as possible and keeping those rates affordable. Again, from an economic development standpoint, many businesses that are in Wyoming or look at Wyoming to be, as far as a relocation, electricity rates are one of the highest items on their checklist. And so if we want to create jobs, we want to try to keep rates low at the same time. And Mr. Chairman, if I may, and for the benefit of the members, Rocky Mountain Power is working on its 2021 Integrated Resource Plan. That will be filed sometime in the third quarter of this year. And it takes into consideration what we heard earlier today too, about carbon capture and storage and how that might be viable. Looking at it on a per coal-fired unit as well. So again, there are developments here, and not knowing what the results may be, but again, that is underway. Instead of, Garrett touched on that, and we've already heard about what unlimited cost externalities might be. We also have, Mr. Chairman, if I can cite this one example. In 2019, Rocky Mountain Power converted its Naughton 3 coal-fired plant to natural gas. And the question from the Public Service Commission at that time is, does this conversion provide reliable electricity at the lowest cost and at least risk? Lowest cost and least risk. The company was able to meet that standard, and today that plant is producing efficiently at a low cost for customers, and it's a reliable generating resource. And there are other examples of what cost externalities might cause.
So Mr. Kaysen, I'm having, don't the PSC or their equivalent in other states ask that question? But then ask also with a reduction of 40% or 20% or a percentage of carbon. Don't other equivalents of our PSC ask that question when they look at rates?
When it comes to cost externalities, Mr. Chairman, I can cite two states that do not and are not allowed to take into consideration cost externalities. Those are the states of Utah and Idaho, in which Rocky Mountain Power also serves. So this would be a step outside of again, the regulatory compact and what other states are also requiring of their regulatory commissions. And does that answer the question, sir?
No, but you did in the negative. We understand. Go ahead.
Well, you want me to try to answer it again then, just to make sure?
No, I understand.
All right. Again, sir, I'll just sum up with, when you take into consideration cost externalities, there is no guarantee that there's going to be improvement of any reliability. And more than likely, the costs are going to increase to the Wyoming customers. And with that, sir, I will try to answer any questions that the members of the committee may have.
Nope, appreciate your indulgence. Hopefully you were able to get all your points across to us.
Well, I have more, sir, but I will be respectful of your time.
Well, I don't want it to be said I didn't give enough time to Rocky Mountain Power to light their trough here. So
just maybe this one last portion then, sir. You'll remember House Bill 200 from last year. And again, that bill is still going through the process at the Public Service Commission to get its final rules in place and regulations in place on that. You'll also remember that bill had a 2% cap on CCUS investment, what have you. So if this bill does move forward, respectfully ask you to consider putting a cap on, for example, 2%. So the impact on our electric rate customers could be minimized.
Okay.
And that'll be my final point at this time,
okay,
sir.
Good point. Thank you. All right, committee, any questions? Okay, we'll move on. We got one more item of public testimony. Okay, so Ken Hamilton was in, and then we'll go to Kristen Gunther. Go ahead, Mr. Hamilton.
Yes, thank you, Mr. Chairman. Briefly, I would just say that I support the points raised by Mr. Magagna regarding the view shed. That's the only real interest I have in this particular piece of legislation. Happy to answer any questions if there are any.
Okay, thank you, Mr. Hamilton. We'll keep moving. I think we understand that issue. Thank you. Okay, Kristen, it's Gunther, right?
Yes,
Yep,
Mr.
go
Chairman, thank you. Kristen Gunther from the Wyoming Outdoor Council. Also, not to be redundant, our concerns around view shed have primarily been covered. We are a group that's very interested in that issue and have supported past legislative efforts to look at siting. Do not support it in this bill. And with that, any questions?
Okay. Oh, thank you. I think we understand that issue as well. Okay. Appreciate your comments. Thank you, everyone. I'm going to go ahead and close public comment. Except for I'm going to give Senator Perkins a couple of minutes if you would like, if he's got anything further to say.
Mr. Chairman, thank you. From your questions illustrated most of the counterpoints I would have already made. I would just also point out that we have not changed the existing law, which you see on page 2 of your bill, beginning on line 5. When you're talking about rates, their obligation of the PSC has always been in determining just reasonable rates for electricity. That hasn't changed with the expect, and nothing's changed in this other than the fact now we're really requiring not only it's not availability or reliability, but both. Thank you, Mr. Chair.
So Senator Perkins, I too wasn't a big fan of the view shed language. So,
Mr. Chairman, it doesn't matter whether the view shed language is in or out. The effect of the view shed is economic.
Yeah.
And so if they're considering economics indirectly, they're going to also consider the effect of view shed. So it doesn't matter whether it's there or not.
yep. Thank you. Okay, I'm going to close public comment. What's the committee's pleasure? Moved by Duncan, second by Gray. Okay. Yeah, let's go ahead. Yep.
Mr. Chairman, I move an amendment on page 2,
Okay.
line 16. After economic, remove that comma, insert the word or. Moving down on line 17.
Do you want or and?
Oh, and, sorry, and. The word and. And on line 17, scratch through the word and view shed.
Okay. Is there a second? Second by Hunter. Any discussion? Seeing none, all those in favor of the amendment, say aye.
Aye.
Opposed? Amendment passes or is adopted. Back on the bill. Question on the bill, roll call. Oh, please, Carl.
Representative Bear,
Aye.
Representative Burkhart,
Aye.
Representative or Vice Chair Duncan. Aye. Representative Air,
Aye.
Representative Gray. Aye. Representative Heiner. Aye. Representative Sherwood,
Aye.
Representative Western, Chairman Greer.
Aye.
9 ayes do pass with amendments.
Okay, thank you, Carol. Appreciate that. Representative Gray, your co-sponsor, you floor managing this? Oh, yeah. Okay, all right.